Let's talk about the Homeowners Association. You know, for some people, it's the guardian of property values, keeping everything neat and tidy. But for others, it can feel like a source of just endless frustration. That tension is super common, but what happens when it blows past a simple neighborhood disagreement and turns into a full-blown, formal legal battle? Well, we're about to find out. I mean, have you ever been there? You get that notice in the mail, you totally disagree with some new rule, and you just feel like there's absolutely nothing you can do about it. But what if you decided to actually fight back? Not with, angry emails, but by taking on the entire system itself. Because believe it or not, there is a formal process for this. It involves filing an official petition, paying some pretty hefty fees, and then actually arguing your case in front of a judge. And one homeowner, a woman named Susan Alandar, did exactly that. Her case is a really fascinating deep dive into how these battles are won and lost, and what it tells us about the power dynamics in probably your own community. So, here's how we're going to break this all down. First, we'll see how this one homeowner took her stand. Then we're going to investigate her specific claims, everything from secret board meetings to a wild standoff with the local Italian-American club. We'll also look at the power a board has over its own meeting agendas. And then, the main event, how the judge ruled, and probably most importantly, what every single homeowner should know from this case. Okay, so our story kicks off on February 3rd, 2020. That's the day Susan Alandar officially filed her petition against her HOA, the Ventana Lakes Property Owners Association. And look, this wasn't some small claims thing. She ended up paying $2,000 in filing fees just to get the chance to argue 4 different issues she believed were serious violations. Her first major charge was all about transparency. She was alleging that the HOA board was interviewing potential new board members in secret, behind closed doors in these executive sessions, which she was convinced was totally against the law. So on the one hand, you've got the petitioner's argument. State law is clear, these meetings need to be open to everybody. But on the other side, the HOA had a pretty compelling defense. They argued, hey, these private sessions are necessary because we have to ask about sensitive personal stuff. For example, they had one candidate whose wife had dementia. That's a really personal situation that could impact his ability to serve, and it's probably not something you'd want to discuss in a public forum. All right, next up is easily the most dramatic part of this whole case. 2 of the homeowners' allegations revolved around this massive conflict between the community's Italian-American club and the board. And it all started with a simple request for some extra tables and chairs, which somehow spiraled into a year-long ban from using any community facilities. Just look at how fast this whole thing blew up. You can see the club was already kind of on the board's radar from back in 2018. Fast forward, they submit their event plan, make a last-minute request on April 3rd, and get denied. The very next day, security cameras catch them moving furniture anyway, which leads to a big argument. And then, just 2 weeks later, the board drops the hammer. A 1-year ban. Done. And here's where they get that power. It's written right into the community's own governing documents, the CC&Rs. And check out that language. The right to suspend any resident. That is some incredibly broad authority. It's a powerful tool, and in this case, they weren't afraid to use it. Okay, on to the final allegation. And this one gets to a question that I bet almost every homeowner has wondered about. If you write to the board and ask them to discuss something, do they have to put it on the agenda for the next meeting? So the petitioner pointed to a very specific rule that seemed to say, yep, the president has to put all written requests on the agenda. Seems straightforward, right? Well, the HOA basically admitted that, yeah, the president didn't include every single request. Their whole defense was that it would just be completely impractical to do that. So who's right here? And that brings us to the climax of this whole story. After hearing all the arguments on all 4 issues, the administrative law judge issued her final decision on July 23rd, 2020. The fight was over. The verdict was in. So, after all that effort, all the fees, the arguments, who do you think won? The homeowner fighting for transparency and what she saw as fairness, or the HOA board defending its authority? The petition was denied. The homeowner lost on all counts. It's a really stark outcome, but the reasoning, the why she lost, that's what's actually important here. Okay, let's just break this down real quick. On the secret meetings claim, the HOA won. On the 2 claims about the Italian club, they were dismissed as moot, and we're going to talk about what that means in a second. And on the agenda requests, the HOA won again. It was a total clean sweep for the association. So the key factor on the secret meetings was evidence. The judge basically said that while the petitioner believed the meetings were for nefarious purposes, she didn't actually provide any proof. And more importantly, the law itself has this specific exception that allows for closed sessions to discuss personal info, which is exactly what the HOA said they were doing. Now, for that legal term, moot. So what does that even mean? Well, in simple terms, an issue is moot if it's already over and done with. If a judge's ruling can't actually change anything in the real world, the court just won't weigh in. The moment has passed, so there's nothing to decide. And this is exactly what happened with the Italian club. The one-year ban ended on April 30th. The hearing wasn't until June 11th, so by the time they all got in front of the judge, the penalty had already been served. It was over. There was nothing for the judge to rule on, so the issue was declared moot. Turns out, timing was everything. And finally, those agenda requests. The judge came down with this key phrase, inherent authority. She ruled that the board president has a built-in power to set the agenda. It means they have the discretion to decide what gets discussed, even if a rule seems to say otherwise, because it would just be impractical to hear every single request from every resident. So after all that, what can we all take away from this? Because this case isn't just one person's story, it's really a masterclass in the realities of what it takes to challenge an HOA. So what does this all mean for you? Well, first, the burden of proof is always on you, the petitioner. You can't just feel like something is wrong, you have to prove it. Second, timing is absolutely critical. Your whole case could get thrown out if the problem solves itself before your hearing date. And finally, just remember that your community's own documents and state laws often give your HOA board really broad authority that judges are often hesitant to overrule. Which kind of leaves us with one big final question to think about. This case followed the letter of the law, for sure, but does it show a system that's truly fair? Or does it reveal a process where the odds and even the rules themselves are often stacked in favor of the association, leaving the individual homeowner with a very, very steep hill to climb?